Motion specially set, motions calendar. Um, Good morning, everyone. Where are we, what are we doing this morning?
Yes, you can start. I believe Judge, Defense Counsel has motions that we are to hear this morning and he can set.
Yes, do you need me to stand in this place?
You need to be heard. We have the court reporter that's online, so you can either stand at the podium or make sure that this microphone is on and speak into it.
Okay, good morning, Judge. Ms. Waldrop and I have been in touch a few times. I think we've narrowed the issues as much as we possibly can. There are pending reasonable suspicions, probable cause motions. We've got a custody issue that we want to be heard on. But I mean, barring that, you have one witness, right?
That is correct.
So that'd be one video, I'm assuming.
Correct.
Do we need to get into the other issues since they're not? Should we approach and talk about that, or is it even an issue?
Approach.
Okay.
Okay, Ms. Waldrop, whenever you're ready.
Judge, is it okay if we turn this off and bless her until I have just push the button, right?
Yes.
Mash the button, as we say.
I do not, I'm sure you can even move that.
Okay, all right.
Yeah.
Okay, Judge. And Your Honor, the state would call Detective Frederick Lee to the stand. You over there?
Why don't we put them over here? That might be easier. Good morning.
Good morning, Judge.
Good morning, Detective Lee. How are you?
I'm doing well.
Good. Can you state and spell your name for the record?
You want to swear him in?
Yes, if you could swear him in, Deputy.
Raise your right hand. Do you swear or affirm that the testimony that you're about to give in this court proceedings, the truth, the whole truth, and nothing but the truth to help you?
I swear.
He's been sworn in.
Thank you.
My name is Detective Frederick Lee. It's spelled Fredrick. Last name Lee, Lee.
And Detective Lee, how is it that you are employed?
I'm employed by Sandy Springs Police Department.
And how long have you been with Sandy Springs?
I've been with Sandy Springs since 2017.
Okay. And how long have you been employed as a police officer total?
Since 2014.
Okay. And where were you before Sandy Springs?
Fulton County Police Department.
And are you post-certified?
I am.
And were you post-certified on September 16th of 2018?
I was.
Can you tell the court a little bit about your law enforcement experience?
Yes, as I stated, I've been a police officer since 2014. I am currently serving as a narcotics detective at Sandy Springs, where I am assigned to the DEA Narcotics Task Force.
And with respect to your duties and responsibilities, what is it that you do specifically?
Currently, I conduct narcotics investigation utilizing surveillance and undercover operations.
Okay. And when did you become a narcotics detective?
Approximately 2 years ago.
Okay. And you said you were with Sandy Springs since 2017. So prior to becoming a narcotics detective, what were your duties and responsibilities and title with Sandy Springs?
Prior to that, I was a patrol officer. I responded to 911 calls, conducted traffic stops, consensual encounters with citizens, things of that nature.
Okay. And did those traffic stops ever involve DUIs?
Yes,
Okay. And as a part of those, did you do DUI investigations at all?
yes.
And when you were with Fulton County PD, what were your duties and responsibilities?
I had the same role. I worked patrol, answering 911 calls, conducting traffic stops and citizen encounters.
Okay. And as a part of the Fulton County Police Department, did you also investigate DUIs?
Yes.
Okay. And how many total DUI investigations would you say that you've done in the course of your career?
I would say approximately at least 50 that I've been involved in or directly conducted.
Okay. And did all of those DUI investigations result in arrest for DUI?
Maybe one or two if it did not, but the majority did, yes.
Okay. And with regard to your specialized DUI training, can you tell the court about that?
Yes, besides the basic training that we get in the police academy, I also got certified approximately 2017 with conducting field sobriety tests on the side of the road and going through those processes.
Okay. Do you recall how many hours that training was?
That is approximately a 40-hour class roughly.
Okay. I want to take you back to September 16th of 2018. I know it was a while ago, but you were employed by Sandy Springs Police Department on that date, correct?
That is correct.
And were you on duty?
Yes.
What were the hours or what time were you on duty?
At that time, I was working from 6 p.m. to 6 a.m.
Okay. And were you in uniform to include your badge?
Yes.
And were you in a marked patrol vehicle?
Yes,
Okay. And did you have an opportunity to encounter an individual named Dontarius Copeland?
yes.
Okay. And how is it that you came aware of the need to, or became aware of the need to, how is it that you encountered Mr. Copeland?
Yes, we received a 911 call of a vehicle blocking the roadway on Interstate 285. I believe the vehicle was supposed to be in the left lane, traveling eastbound.
Okay. And you said this is at I-285?
Yes, ma'am.
Any other exits or crosswalks?
Oh, near the North Side Drive area.
Okay, and is that location squarely within the bounds of Fulton County?
Yes.
Okay. And when you arrived on scene, what drew your attention to the defendant?
At that time, my sergeant had already arrived on scene, and he notified me that there was a young man in the vehicle, currently asleep or passed out. We basically tried to wake him. He did not wake up. So we decided we would try to turn the vehicle off just in case he did wake up, so he wouldn't drive off, and see if we could get him to come out of the.
Okay, so when you first came upon the scene, what exactly did you see?
Oh, as I arrived on scene, I saw my sergeant's vehicle parked behind a vehicle that was stopped in the left lane.
And would you say that the vehicle stopped in the left lane was impeding traffic?
Yes.
Let me ask you a couple of questions about cameras. At that time, was it routine for Sandy Springs police cars to be equipped with a camera?
Yes.
Okay. Do you recall what type of equipment was installed?
I believe it was called like an L3 camera system. It was a bit of an older system, so I'm not 100% sure on the name, but I believe that's what we referred to it as the L3 system.
Okay, and can you tell the court how the camera operates with respect to turning it on?
Yes, you could turn it on manually. However, if you activated your lights and sirens, it would automatically activate the camera.
And to your knowledge, were the cameras working in that vehicle? Were they working normally and properly?
Yes.
Okay. And I'm going to show you just a brief portion of some video. We're getting there, Judge. Is there another option? Okay. And Detective Lee, is this the tape that has the stop of the defendant?
Yes,
Okay. And the angle of the camera, what angle is that? What does it record? What angle?
this is the dash cam
Okay.
of, I'm assuming this is Sergeant Godfrey's vehicle.
Okay. And so what angle does it record?
Oh, it records forward.
Okay. So this is a head-on angle of
Yes,
the defendant's vehicle, is that correct?
that is correct.
Okay. And have you had an opportunity to view this tape before today?
Yes,
Okay. And is this video a fair and accurate recording of the events that took place during your involvement with this case?
it is.
Okay. Your Honor, at this time, the state would tender into evidence the dash cam video.
Any objection?
Can I cross him briefly?
Yes.
Is this not your video?
No, sir. I think this is Sergeant Godfrey's video, but there's no labeling on it to be sure, but I believe this is his actual vehicle.
Okay. Is this the video, though, that has the defendant stop recorded, and is it a fair, accurate representation of
Yes,
that?
absolutely.
Okay.
How do you know this is the defendant's vehicle?
How do I know this is the defendant's vehicle?
Right.
Based off of the tag in the white vehicle. It's
You
the
can-
vehicle we encountered when we arrived.
You can read the tag in that?
No, sir. Are you asking if I know the vehicle belongs to him?
Well, look, I guess we're getting a little ahead of ourselves. For purposes of authenticating this video, this is not your video.
This is possibly Sergeant Godfrey's dash cam video.
Okay, but how are you sure this is an accurate representation of what occurred the night that Mr. Copeland was arrested?
Oh, because I was there.
Approximately how long after Sergeant Godfrey arrived did you arrive?
Possibly
Detective Lee?
a minute and a half to 2 minutes at most.
Okay.
Yeah.
And when you pulled up, what is it that you observed?
The same thing we're looking at, a vehicle stopped in the roadway, and Sergeant Godfrey was standing on the side of the road.
Okay. Where was Sergeant Godfrey in relation to the vehicle?
In relation to the vehicle, he was on the shoulder, on the left shoulder, if that will
Okay.
help, standing near closer to the driver's side.
Okay. And Your Honor, at this time, he's testified that it is an accurate depiction of the events of that night, that he was there. And I would ask to tender the video into evidence.
Any objection?
Only to the extent that it doesn't appear to be his vehicle, his video. If the court rules that he's authenticated it, then I'm willing to move forward. But if there's another video that might have him in it, I wouldn't have a problem with that.
When you watched this video, did you see yourself in the video?
Yes, a few minutes, no, I'm sorry. A few minutes after Sergeant Godfrey stopped, you see me walk up as well.
That's for some reason. Show you.
There's one over here if there's an extension cord.
I apologize, Judge. I thought we had an outlet over here.
You wanna,
Okay.
what, there's another one beside it. What about this one here?
Same thing.
So what would the court like for me to do?
This one I can't take on. If
You wanna move the video,
could-
the camera and the TV over to there, there's an outlet. over
you
there.
could come over here. I have some plugs over here if you wanna.
Can we stretch it over here?
Oh,
You got it? Yeah, can you just pull it up?
If you can stretch it over.
Can we stretch that
Can
over
you
here?
put your laptop
I
here?
didn't know, 'cause
Can you
this
stretch
is-
it across?
taped.
There we go.
Because my. that is- Yeah. Okay. And I do apologize, Judge.
Okay, you're fine.
With respect to the video, state would request to tender into evidence the video.
Is there an objection?
No objection.
Admit it without objection.
Okay. This time I'm going to play.
$250, are you on main? Or are you on tag?
Okay, go ahead, please. I got stuff on the highway.
If I've got one contact line on here. Sierra 3. Block here.
Let's stop it there. And Detective, is that the extent of the interaction with the defendant that is captured on this video?
Yes,
Okay. You stated that you pulled up in response to a 911 call that a vehicle was in the middle of the lane blocking traffic. Is that correct?
that is correct.
Okay. And when you pulled up, did you go up to the vehicle to find out what was going on?
Yes.
Okay. And can you tell the court, explain that to the court and describe what happened?
Yes, so initially we pulled up, you could hear my sirens in the background trying to slow traffic and get them to move over. I exited the vehicle. As I walked up, Sergeant Godfrey spoke to me and said since the guy was unresponsive, he would like to turn the vehicle off so the vehicle wouldn't roll if something happened. He was unable to reach it. Because I'm a little taller, my limbs are a little longer, I reached in, put the vehicle in park, turned the vehicle off. At that time, the defendant appeared to be waking up or appeared to.
Let me stop you there. When you first got up to the
Mhm.
car, was the vehicle, was the defendant conscious and alert?
No.
Okay. And did you attempt to awake the defendant at some point?
Yes, I shouted to him a few times just to see if he would respond, but there was no response.
Do you recall how many times to you?
I do not, maybe 2 or 3.
Okay. And did Sergeant Godfrey also attempt to awake the?
Yes, while I was on scene, he spoke to him once or twice as well.
Okay. And you stated that he remained unresponsive at that point?
That is correct.
Is that when the driver's side door was opened?
After we turned the vehicle off, then we opened the driver.
Okay, so what you're saying is that the vehicle was, number one, it was on
It was.
and the engine was running, is that correct?
It was.
Okay. Do you recall whether or not, what gear the vehicle was in?
I believe it was in drive.
Okay. So you reached into the vehicle to turn it off so that it did not move, is that correct?
That is correct.
All right, and then what happened?
And then as we came out of the vehicle, the driver began to somewhat respond. We were able to wake him up a little bit. I don't think he was fully conscious at that point. And that's when we made the decision to basically remove him from the vehicle.
Okay. How close were you to the defendant on scene?
I was very close. I was close enough to touch him.
Okay, would you say mere inches from what we
Yeah,
saw in the
yes.
video? Okay. Did you notice any odor about the defendant that you could identify?
Yes, as he awoke, he began to kind of, I guess, ask what was going on. You could kind of smell the odor of alcohol coming from his breath.
Okay, and how is it that you identified it as alcohol?
Other than my previous DUI investigations, just in regular life, I come in contact with people who have been drinking. So I'm very familiar with the smell.
And how strong was the odor, would you say?
It was pretty strong.
And where did it appear to be coming from with respect to the defendant?
It appeared to be coming from his breath.
At some point, did you attempt to learn the identity of the defendant?
At some point, I think we did.
Okay. And did you ask him for his license and things of that nature?
Yes, generally we ask for identification.
Okay, so you had an opportunity to hear the defendant speak, is that correct?
Yes.
Okay. Did you notice anything with respect to the speech?
It appeared to be slurred.
Okay. But you had never encountered the defendant prior to this night, correct?
No, ma'am, I have not.
Okay, so what makes you think that his speech was slurred?
Just to my training experience and knowledge.
Would you say the defendant maybe had an accent and that could have accounted for the slurred speech?
I don't think so, no, ma'am.
Did you have an opportunity to observe the defendant either stand or walk when you got him out of the vehicle?
Loosely.
Okay, can you describe that?
He appeared to need our support. As we escorted him from the vehicle, he seemed to be kind of leaning a lot of his weight on us.
Okay. Could the defendant stand or walk without the support of you and Sergeant Godfrey?
I don't think he would have been able to stand normally, stumble a little.
Would you say he was unable to maintain his balance?
Yes.
Okay. Did you observe anything regarding the defendant's face or eyes or anything?
No, not that I can recall.
Okay. Did you ask the defendant how it is that he came to be stopped in the middle of the interstate?
Yes.
Okay, and what was his response?
His response was that his tires were blown.
Did you notice anything about the tires on the defendant's vehicle?
Yes, the tires appear to be fully functional.
Okay. Now we see you and Sergeant Godfrey take the vehicle, take the defendant out of the vehicle. At that point, had you detained the defendant?
Yes, ma'am, just in reference to the traffic stop here.
Okay. Had you told the defendant that he was under arrest at all at that point?
No, ma'am.
Did he indicate to you that he had been drinking or anything?
He did not say anything that I can recall, other than the things that I've mentioned.
Did you have the impression that he had been drinking?
Yes.
And what was it that gave you that impression?
Other than the odor and his inability to stand on his own, the fact that he was stopped in the middle of the roadway, the vehicle still in drive, that is common with drunk drivers in the middle of the night.
Okay. Effectively, do you recognize the individual in that video that you pulled from the driver's seat of that vehicle?
Yes.
Okay. Can you point him out and describe where he's seated and what he's wearing?
Yes, it's the defendant to the right of me wearing a white polo, blue collar.
Record reflect that the detective, the witness has identified the defendant.
So reflected.
Okay. You recall how long it took for you and Sergeant Godfrey to get the defendant to be responsive?
Oh, possibly a minute or so.
I know that you said that you are certified in conducting field sobriety evaluations. Did you ask the defendant to perform any field sobriety evaluations in this particular case?
No, because of his, at that time, obviously safety reasons and his lack of balance. I did not want him to hurt himself.
So is it your testimony that you don't believe that the defendant could have performed the field sobriety evaluations due to his intoxication?
Correct.
Okay. And as a police officer, have you had the occasion to observe people who are under the influence of alcohol?
Yes.
How many times would you say?
About 50 out, during the investigations, but outside of the investigation, I would say maybe 1,000 in regular life.
And are the manifestations that you observed with the defendant consistent with someone who was under the influence of alcohol?
Yes.
Okay. And based on your experience and your training and your observations that night of the defendant's vehicle in the middle of the interstate, his speech, his demeanor, the odor that you smelled, all of those things that you just testified to, do you have an opinion as to whether or not the defendant was under the influence of alcohol to the extent he was less safe to drive that night?
Yes, in my opinion, he was intoxicated.
Okay. To the extent that he was less safe?
Yes.
At some point, was the defendant arrested?
Oh, yes.
At what point did that take place?
Later on in the traffic stop, I read him the implied consent.
Judge, I'm going to object to any testimony as to implied consent based on the previous discussion that we've had.
Yes, if you could just tell the court at what point he was arrested with regard to the
Oh, at the end of the traffic stop, we tried to get him to submit a breathalyzer test.
Without speaking to any type.
Oh, got you. Okay.
He arrested later on, not at this point in the video.
Yes.
Nothing further from the state at this time, Judge.
Would you mind playing that back to when they? Judge, I just asked the prosecutor to run it back a little bit so we could watch this before I ask him any questions. Good morning, Detective.
Good morning.
I've got a few questions for you. And I'm going to try and go in order of which you answered questions. I might move around a little bit. I hope that's okay.
That's fine.
Let's talk about your DUI training first. You said that you'd had the standardized field sobriety training in the basic training, the 40-hour training, correct?
Yes, sir.
Do you recall when that might have been?
Approximately 2017.
That would have been, was that before this arrest?
Yes.
Do you have any specialized DUI training like A-RIDE or DRE?
No, sir.
You did mention that you had participated in approximately 50 DUI investigations. How many DUI investigations had you participated in as of September 18th, 2018, when Mr. Copeland was arrested?
A best estimate would be maybe 30 or so.
And of those 30, how many were arrested for DUI, if you recall? I know you're just being general.
Yeah, just general. I would say at least maybe 95% of them.
Were those arrests made directly by you or with the assistance of another officer, if you recall?
A combination of both. I would say the majority were by me. Later on, once I got to Sandy Springs, a lot of my investigations were taken over by like a traffic unit that specializes in DUIs.
So it was your testimony that when you first approached the vehicle was in fact impeding traffic, correct?
Correct.
Did you charge Mr. Copeland with impeding traffic?
I do not believe we did.
It was just the DUI?
I believe it was just the DUI.
And that was an A1, a less safe DUI, correct?
Yes, sir, if I remember correctly.
Now, do you recall were his hazards flashing on the car when you first walked up to him?
I don't recall. I do remember seeing the brake lights. I can't recall whether the hazard lights were actually on.
Was his foot on the brake?
Yes,
And let's talk about the car. Nobody else in the car, right?
that is correct. No one.
Was he wearing his seatbelt?
I believe he was. I'm
Dude.
trying to recall, but
I understand it's
Yeah.
been 5 years. Do you recall whether his seat was reclined or if he was erect in the seat as if he had just recently been driving?
it's kind of hard to say because, I would say it's semi-reclined. I mean, yeah, I wouldn't say it was reclined all the way to the point where he was laying down, no.
Could we agree that it might have been a position where he could have been driving at that point?
Absolutely, yes.
I think we could maybe call it riding low. Right? He might have
Okay,
been
yeah, exactly.
riding low, but he wasn't fully reclined, right?
Correct.
Okay. It was you that turned the vehicle off, correct?
Yes.
Did you take Mr. Copeland's keys?
I believe we did remove them from the vehicle.
Do you know what happened to him after you removed him from the vehicle?
I could not say no, sir.
You didn't give it to Mr. Copeland, did you?
No, sir.
Did you ever see Mr. Copeland operate a moving vehicle?
No, sir.
Who made the decision to remove Mr. Copeland from the vehicle? Was it you or was it Sergeant Godfrey?
I believe it was Sergeant Godfrey at that time.
Okay, so let's talk about the physical manifestations.
Okay.
The most immediate that I think you testified to was the odor of alcohol.
Yes.
Now, can you and I agree that you can't tell how much someone's had to drink just by smelling alcohol?
Absolutely.
Could we agree that you can't tell what time he had that to drink
Yeah, absolutely.
or what kind?
Yeah.
There was never any question as to directed towards Mr. Copeland as to what he'd had to drink, was there?
No, sir. I'm assuming you're asking, like, if we asked him what he drank.
Yes, sir.
I do not recall asking him that specific question.
And can you and I agree that odor alone would not indicate that someone is impaired?
That is correct.
Okay. Let's talk about his speech then. You did say that his speech was slurred, but I understand the prosecutor did also ask you if you'd ever met him before.
That is correct.
Is it possible that his speech was slurred because, to your testimony, he might have been asleep at the time you woke him up?
It's possible. I wouldn't say it's normal, but it's possible, I guess.
You would say or wouldn't say it's normal?
I would not say it's normal.
Okay.
But you know.
And you didn't detect an accent at all?
No, sir.
Does your training for DUI investigations allow you to rely on slurred speech as an indicator of impairment?
Not solely, no, sir.
When you say not solely, is it in conjunction with other things?
Yes, it can be in conjunction with other things.
What kind of other things?
The smell of alcohol on the breath, their lack of balance, things of that nature.
So let's talk about the lack of balance. Now, as I see the video, Sergeant Godfrey took one of Mr. Copeland's arms and you took the other arm and assisted him out of the vehicle, correct?
That is correct.
Was there any point between the time he came out of the vehicle to the time he was placed in your patrol car that he was not physically restrained by a police officer?
No, sir.
So that whole entire time, somebody had hands on him, right?
Someone had hands on him, correct.
Could you and I agree that, you know, having two officers kind of push and pull to get you out of the car, could you and I agree that might give an indication that someone was a little unbalanced?
It's possible. I could agree with that if that's what was happening.
Okay. How far behind Sergeant Godfrey's vehicle did you park your vehicle, do you think?
My vehicle was maybe, I would say, less than 20 yards. It was positioned more so to block traffic from that lane next to the vehicle, so that cars would have to go around.
And I've seen your vehicle. I'm sorry, I've seen your video. Have you watched your video on this case?
Yes, sir.
Okay, so would you agree with me? And I'm just going to kind of, from my recollection, I see you kind of serpentine.
Yes.
And that's to stop traffic behind you, right?
Exactly.
You got all the lights and sirens going.
Correct.
And that's a safety feature for you and for Mr. Copeland.
Yes, correct.
And then once you feel like you've kind of got that traffic under control, you move, you say about 20 yards behind.
Yeah, if I just had to guess. Yeah.
And I think it's one lane over.
Yeah.
Okay. So if we're and if we're talking lanes too, I know the standard is to go from inside out 1, 2, 3, 4,
Right.
and there's like 50 lanes on 285
It
at that
is.
point. So my understanding would be that Sergeant Godfrey's vehicle is behind Mr. Copeland's in lane 1, and you're about 20 yards behind in lane 2.
That is correct.
Who puts handcuffs on Mr. Copeland?
I believe it was me, if I can recall.
And that was at the moment that Mr. Copeland was taken out of his car, correct?
That is correct.
So then you or Sergeant Godfrey together walk Mr. Copeland back to your car?
Yes.
Do you recall if it's just you or if it's also Sergeant Godfrey?
I believe we walked them together.
Okay. So you guys together walked him, you say about 20 yards?
Yes, sir.
It's football season, so yards make sense to me now.
Mhm.
You're walking about 20 yards and then you put him in the back of your police car
Yes.
and you shut the door.
Yes.
Do you know who he is at this point?
I do not believe so.
Okay. And during that entire period where you walk him from his vehicle to your vehicle, he's restrained in handcuffs. He's got his hands behind his back.
Yes.
I'm sorry, that's a compound question. Was he restrained in handcuffs?
Yes.
Were his hands behind his back?
Yes.
And you and Sergeant Godfrey escorted him, correct?
Correct.
Was he under arrest at this point?
No.
Was he free to leave at this point?
No.
Now, with respect to the statement, well, let me back up a little bit. So your report in this case, you filed a report with the Sandy Springs Police Department, correct?
Correct.
And in your law enforcement training, your reports you're taught at least to be accurate with your report
That's correct.
and to be truthful with your reports
Yes.
and to be complete with your reports, correct?
Yes.
Okay. And would you categorize your report in this case as being accurate
Yes.
and truthful
Yes.
and complete?
Yes.
Now, your testimony is that Mr. Copeland responded to you, his tires were blown. If we were to watch your video, would your video in fact show that he said he was worried his tires were going out? Would you recall that from your video?
I wouldn't recall maybe the exact statement, but I know it had something to do with his tires because of course it was 2018.
Right. It's been 5 years, right?
Yeah.
Okay. So we can agree that a blown tire is one thing and a tire that's going out means something different. Could mean something different to everybody.
Yeah.
Do you have his video available to? But you know what? I don't think it matters at this point. I don't think it matters at this point, but I appreciate you trying to help me with that. Along that line of questioning, he could have said that his tires were blown, right?
He could have.
He could also have said his tires were going out, correct?
Absolutely.
Now, where was he when he made this statement to you?
If I had to recall, he was on the side of the road. It possibly could have been in the back of the car. But I believe it was on the side of the road.
About how long after you placed handcuffs on Mr. Copeland did he make this statement, if you recall?
I couldn't recall the time frame.
Do you recall about how long you were on the side of the road with him?
Total, maybe 15, 20 minutes. It depends.
And I guess the most polite way to say it is that he left it as your escort, right? You were
Absolutely.
escorting him away from the scene.
Yes.
And you placed him under formal arrest at some point post this time.
Correct.
Do you recall about how long after you placed handcuffs on him you actually said you are under arrest?
I do not.
Do you recall what you told him he was under arrest for?
Specifically, no, but if I had to guess, it would have been for DUI.
Can I have a moment with my client, Judge? Thank you. Technically, thank you, sir. I'll tender the list.
Any redirect?
Just briefly, Judge, Detective Lee, what was the purpose of your questioning that occurred on the side of that road when you had gotten the defendant out of the vehicle, that initial questioning?
The initial questioning is just to figure out what's happening on the scene, to figure out why he stopped on the interstate.
Okay. And have you previously, in your experience, had the opportunity to encounter vehicles that are stopped in the middle of the road or on the side of the road, or even parked with a driver passed out in the driver's seat?
Yes.
Okay, and in those previous experiences, were you able to awake the driver and get them talking to you?
Generally, yes, ma'am.
And when they began talking to you, did they speak with you in a slurred manner due to having been awakened or asleep at one point?
I don't think it was because they were asleep. I think it was because
Okay.
they were intoxicated.
Okay, and would it be fair to say that the reason someone had hands on the defendant during this encounter is because he could not stand on his own? Is that fair?
That is correct.
Okay. Nothing further, Judge.
Just brief redirect, Judge. Detective, were you concerned about his medical safety at the time that you placed the restraints on him?
No, my assumption at that point was that he was possibly intoxicated.
Is that the reason you put the handcuffs on him?
That is not the reason. It was more so for safety. Us being in the middle of the road. Generally, our next step is to move the vehicle out of the roadway to avoid a traffic collision. Also, it is normally our concern because, of course, us awakening him, he could panic and run out into the road and get hit.
You actually raised a good point. Was his vehicle left on the left side of the road?
It was not.
Who moved it?
Another police officer moved it.
Okay. Do you recall offhand if that was,
No, sir, not exactly who moved it, but I know it was moved.
might have been Sergeant Godfrey, might have been Detective Inman. I think he showed up at some point.
It could have been, yes, sir.
Nothing further, Judge. Thank you.
Thank you, Detective. We appreciate it.
Judge.
Call your next witness.
The state, West Judge, we don't have any other witnesses.
Mr. Kilgo?
No witnesses, Judge, just argument.
Yes, Judge, with respect to the 3 points that defense counsel laid out, or the 3 issues rather, I'll start with reasonable articulable suspicion. I think the state has more than met its burden on that particular issue. First and foremost, this was not a stop. The officer did not observe the vehicle traveling and then conducted a traffic stop. You heard testimony that they received a 911 call regarding a vehicle that was stopped in the in the middle of the first lane of travel on Interstate 285. And so they were responding to that call. When they arrived, they observed exactly what the caller had described, which was a vehicle that you see on the video, stopped in the first lane of travel in the middle of the road, impeding traffic flow. They then approached the vehicle and observed the defendant passed out in the driver's seat. The engine was running, the ignition was on, the keys were in the ignition, and the vehicle was in drive. So, Your Honor, we have reasonable articulable suspicion with regard to this case. It's a very, very low standard that I believe that the state has met. With regard to probable cause, Judge, I don't think there's any doubt that the defendant had been driving the vehicle prior to officers' approach. As I stated, he was in the driver's seat. The engine was on, the gear was in drive. In addition to that, he was impeding traffic flow, so there was a less safe act at this time that they encountered the defendant. And with respect to physical manifestations, that gave the officer the indication that the defendant was under the influence of alcohol. He could smell the strong odor, what he described as a strong odor of alcohol. He knew it was alcohol because based on his experience, that is what it smells like. You heard him testify that he has encountered people who have been under the influence of alcohol, I think thousands of times. And so there was no doubt in his mind as to what that smell was. He testified that it was coming from the defendant's breath. In addition to that, Judge, with regard to probable cause, he testified that the defendant, upon them pulling him out of the vehicle, was immediately unable to maintain his balance. He was so unsteady that officers had to essentially hold him up and then keep a hand on him so that he did not fall over, and had to assist him in actually walking. You heard testimony that the defendant's speech was slurred. I did ask the detective, how would he know that, having not encountered the defendant prior to this night or heard him speak previously? And he was very clear that the slurring that he heard was not attributable to any type of accent, and that based on his experience, it was slurred speech consistent with someone intoxicated or under the influence of alcohol. The officer could not safely perform field sobriety evaluations on the defendant because the defendant was, as you heard testimony, too intoxicated to even stand on his own. And so it became a safety issue, them being on the side of 285, a very heavily traveled interstate in Fulton County. And so, Judge, taking into account the totality of the circumstances, I think the state has more than met its burden. It's the low burden of probable cause with respect to this case. And with respect to the statement of the defendant that his tires were blown. And then you heard testimony from the detective that he looked at the car and did not appear that the tires were blown or flat. They appeared to all be fully inflated. That statement was made by the defendant as a part of the preliminary initial investigation that you heard Detective Lee testify to that occurred right there on the side of the road. They were asking the defendant how it is he got to the side of the road, trying to figure out what was going on. And so I would argue to the court that while you did see the defendant be placed in handcuffs, you heard testimony that that was for the safety of the defendant. And at that point, he wasn't necessarily in custody because you heard Detective Lee testify that he was detained and that they were asking him initial questions as part of a preliminary investigation. And so, Judge, I would ask that you deny all of defense's motions, as I believe that the state has met its burden in this case.
Thank you, counsel.
Thank you. Judge, I'll submit on reasonable suspicion. Somebody stopped on 285 is obviously a danger to everyone. So I think there's a reason the police officer should be out there to determine whether everyone's safe. With respect to probable cause, though, I believe there's a disconnect between the driving and the manifestations. I think you heard testimony from Detective Lee that, those manifestations themselves would not be indicative of an impairing level of alcohol. And I think we can all agree that the mere odor of alcohol alone would not be enough to assume that someone is under the influence. So to the extent that probable cause can be found here, as I said, I don't believe there's enough evidence that's been brought to the court to indicate that there's even probable cause to believe that Mr. Copeland was under the influence. There's no testimony as to the manner of his driving. There's no testimony even that he had been in control of a moving vehicle. And even if he had been in control of a moving vehicle and the odor of alcohol, there's no testimony that those two together, that there was an impairing level of alcohol at the time that he was operating that vehicle. So I would ask that as far as probable cause goes, that you grant our motion, that there's insufficient evidence to provide probable cause for an arrest for DUI. I mean, the fact is, you know, I can't fault Detective Lee for doing the job that he was trained to do, but I don't think in this case there were sufficient facts to lay a charge of DUI against Mr. Copeland. With respect to the custody, I have to tell you, I didn't bring this case, and I'll be happy to provide a copy both to you and to Ms. Waldrop. I was ready for other issues, and we resolved all those other issues. So, as we all know, custody is objective, not subjective. It would be a determination of the facts under a reasonable person standard. The most recent case on that is Lopez versus State. This just came out in June. But it's not new information, Judge. It's information that you've heard. It's information that Ms. Waldrop and I both dealt with many, many times over the years. In determining whether someone is restrained to a degree associated with a formal arrest, whether a reasonable person in the suspect's position would have thought the detention would not be temporary is the key. That's the key. Whether a reasonable person. It is the reasonable belief of an ordinary person under certain circumstances, and not the belief or the intent of the officer that determines whether an effect has been arrested. I'm sure Detective Lee believes, based on his training, that he merely detained Mr. Copeland. And I'm sure Ms. Waldrop believes, based on her training and her long experience in prosecution, that he was merely detained. The fact is two police officers reached into his car, turned off his car, took his keys, and placed hands on him even before he was taken from the vehicle. Now, there's a lot that's been made of the fact that he was unsteady on his feet. He's got 4 extra hands on him at every point between the time he's taken out of his car to the time he's walked 60 feet to a police vehicle and shuttered inside. Now, I didn't ask Detective Lee if those doors open from the inside on a police car, because that's a question I don't think any of us have to ask to know the answer to. Mr. Copeland was taken out of his car, placed immediately in handcuffs, and walked 20 yards, 60 feet, by 2 officers and then placed in another police vehicle. And he didn't exit that police vehicle until he got to a police department, to a police station. In fact, his vehicle itself was taken over by another person and moved away. Under any reasonable standard, any person in these circumstances would have believed he was no longer free to leave. Now, the question is not whether he was formally under arrest, it's whether or not he was in custody. Remember, Miranda refers to a custodial interrogation. A custodial interrogation, whether or not that detainer arises to the level such that that individual believes he is no longer free to leave. I'll provide both you and Ms. Waldrop, and I apologize again, with a copy of Lopez. It's just from June of this year. And I can tell you what the best head note in the case says. Defendant was restrained at the time he made restraint associated with an informal arrest, and thus was in custody for Miranda. At the time he made incriminating statements, and this is in regard to an aggravated assault. Following, the officer told him some things about having a knife, but the defendant was then transported to the police department headquarters and back to the patrol car. Uniformed officers with guns escorted him from the parking lot to an interview room, and he was interviewed. Now, this is more than 3 hours after he was arrested. It's clear this wasn't 3 hours. The testimony, I believe, at the side that Detective Lee gave at the side of the road was about 15 minutes. And we don't know how long into the custody those questions were asked. But I believe that based on what we've seen, there's an issue as to degree as to how much he himself could move. You know, it's hard to say that someone's unsteady on their feet when they got 2 police officers jerking them in different directions. But for purposes of custody, I would respectfully submit that at the time Mr. Copeland's keys were taken from his car, his door was opened, he was forcibly removed and immediately placed in handcuffs by 2 uniformed police officers, both of whom were wearing firearms, both of whom in police cars, and then walked 60 feet and placed in the back of the patrol vehicle, he was in custody at that point. Now, the testimony, as I believe, is that at some point he was either in the back of the car or was taken out again, and that custodial statement was made. So I would ask that any statements made after the point he was taken out of the vehicle, and I really think we're just talking about this testimony or this statement about his tires being blown. When the evidence truly comes to light, I believe you'll see that the statement made is that my tires were going out, not in fact that the tires were blown. But I would ask that any statement made from the point that he's placed in handcuffs, walked 60 feet, and placed in the back of a police car be suppressed as a custodial statement made by virtue of the protections in the Miranda. Thank you.
Are there any other statements that you know of other than the issue of the tires that were made?
I don't think there's anything other than Angela, do you? No, Judge, I don't believe that there are. I have the videos here if the court wants to see them.
No, I'm just wanting to know if there's anything more that I need to be considering other than.
Off the top of my head, I don't think there's any other statements. I would ask that anything that he said in that context be suppressed from that point forward.
Ms. Walter.
Your Honor, if I may, I heard counsel speak to probable cause. I know he agreed that we have met the burden of reasonable articulable suspicion. So I heard him say that with regard to control of the vehicle, Your Honor, they don't have to actually see the defendant driving the vehicle. Here he had physical control. He was in the driver's seat, the engine was running, the car was on, the keys were in the ignition. And additionally, Judge, the state does not have to prove less safe driving, just that the defendant's ability to drive was less safe based on their observations. All of these observations which occurred prior to the defendant making these statements, when they pulled him out of the car and they first approached the vehicle and came upon him. The case of Durant v. State indicates that in the absence of field sobriety tests, an officer's observations that the defendant in that case had bloodshot, watery eyes and exuded an odor of alcohol was sufficient to show probable cause to arrest him for driving under the influence of alcohol. Your Honor, we have so much more than that here. We've got the odor without, belaboring the point, but we've got the odor, we've got the unsteadiness and the inability to walk on his own. We've got that he was passed out in the driver's seat of the vehicle, that he was stopped in the middle of the first lane of travel, that his speech was slurred. So the totality of the circumstances, Judge, indicated to this officer, and he testified that the defendant was less safe to drive. And that was the basis for the arrest. The Detective Lee also testified, you heard testimony that at the time that the statements regarding the tires were made, they were on the side of the road. They had just taken him out of the vehicle, and this was a part of his initial and preliminary questioning of the defendant to find out what was going on. This was, as defense counsel admits, a very, very minimal detention. It was not for a lengthy amount of time. It was about 15 to 20 minutes, I think is the testimony that we heard. And at that point when the statements were made, the defendant had not yet been transported to the patrol car. They were made, as part of the initial preliminary investigation there on the side of the road when they took him out of the vehicle. I do have a copy of Durant v. State if the court would like to see it. But for those reasons, we would ask that you deny defense counsel's motions.
Anything further, counsel?
No, thank you, Judge.
All right. Well, you all agree on the reasonable articulable suspicion. So there is no issue there. As far as the probable cause goes, I'm going to deny the motion in regard to that. I believe there's sufficient probable cause in this case to move it forward. As related to the only statement that I know of, which is the statement regarding the tires, I don't know how that's even here nor there, but if that's something that you all still would like to argue over, I'm happy to take into account whatever case that you want me to look into in that matter. So I'm not going to make a ruling on that right now. I'll give you the opportunity to give me the opportunity to look at that case, and if the state would also like for me to look at something, then I'm happy to look at whatever you have in that regard.
Yes, Judge.
I don't know if that's will be a determinative factor. I hope that you all can still continue to see if you can resolve this matter. Okay. All right, and just for the record, I didn't do this. I'm sorry, Ms. Greenhouse, so let me do it now. This was a case of Dontarius Copeland, State versus Dontarius Copeland, case 20 CR 0021882C. Ms. Waldrop, would you, just so Ms. Greenhouse has it on the record, would you give your full name for her?
Yes, Ms. Greenhouse, Angela Waldrop for the state.
And Mr. Kilgo?
Yes, it's Matt Kilgo. My bar number is 661570, MATTHEWKILGO.
Okay. Do you have everything that you need, Ms. Greenhouse?
Yes, Judge. Thank you very much.
Okay, thank you. Anything further this morning?
Thank you, Judge.
If not, you all have a good rest of your day.
Thank you, Your Honor.
And I think that concludes the court's business for today. Always good to see you, Ms. Greenhouse.
Thank you, Judge. You too. Bye-bye.